The definition of sexual harassment in the workplace is the same as the definition of sexual harassment anywhere. An unwelcome sexual advance, request for sexual favors or other unwelcome conduct of a sexual nature which a reasonable person would anticipate would cause a person to feel offended, humiliated, or intimidated constitutes sexual harassment. Sexual harassment of women at the workplace, Prevention, Prohibition and Redressal Act, 2013, prior to the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013, the definition of sexual harassment was laid down by the Supreme Court of India in its landmark case Vishaka vs. State of Rajasthan. It was laid down that Article 19, 1G, of the Indian Constitution affirms the right of all citizens to be employed in any profession of their choosing or to practice their own trade or business. Actions resulting in a violation of one's rights to gender equality and life and liberty is in fact a violation of the victim's fundamental right under Article 19, 1G. The case ruling established that sexual harassment violates a woman's rights in the workplace and is thus not just a matter of personal injury. It replaced the Vishaka Guidelines 1997 of the Supreme Court. The Sexual Harassment at the Workplace, Prevention, Prohibition and Redressal, Act and Rules, 2013 have been notified by the Ministry of Women and Child Development from December 9, 2013.
No woman shall be subjected to sexual harassment at any workplace, be it public or private. Contribute to realization of their right to gender equality, life and liberty and equality in working conditions. Sense of security at the workplace in order to improve women's participation in work, resulting in their economic empowerment and inclusive growth. Sexual harassment has now been defined as any advances to establish physical contact with a woman, a demand or request for sexual favors, making sexually colored remarks, showing pornography or any other form of physical, verbal or non-verbal conduct of sexual nature. Sexual harassment includes but not limited to verbal, nonverbal or physical conduct such as obnoxious comments or utterances, remarks or jokes, letters, phone calls, SMS or emails, gestures, stalking, sounds or display of a nature with sexual overtures. Conduct is not sexual harassment if it is welcome. For this reason, it is important to communicate, either verbally or in writing. Communicate to the harasser that the conduct makes you uncomfortable and you want it to stop.
Implied or explicit promise of preferential, detrimental treatment at the workplace. Implied or explicit threat about her present or future employment status. Interference with her work and/or creating an intimidating or offensive or hostile work environment for her, and humiliating treatment likely to affect her health or safety. There are few terminologies to understand the act in a better way. First one is workplace. While the workplace in the Vishaka guidelines is confined to the traditional office setup where there is a clear employer-employee relationship, the Act goes much further to include organizations, department, office, branch unit etc. in the public and private sector, organized and unorganized, hospitals, nursing homes, educational institutions, students in school and colleges, sports institutes, stadiums, sports complex and any place visited by the employee during the course of employment including the transportation. How is an employee defined as per the Act? A person employed at a workplace for any work on regular, temporary, ad hoc or daily wage basis, either directly or through an agent, including a contractor, with or without the knowledge of the principal employer, whether for remuneration or not, or working on a voluntary basis or otherwise, whether the terms of employment are express or implied and includes a co-worker, a contract worker, probationer, trainee, and apprentice or called by any other such name, who is an aggrieved woman. In relation to a workplace, a woman, of any age whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent, who is a respondent, means a person against whom the aggrieved woman has made a complaint. Let us see the procedure of filing the complaint of sexual harassment. Every complaint must be given in writing to the Internal Complaint Committee within a period of 3 months, from the date of the incident. An extension of a period of 3 months can be granted to the woman if she, due to certain circumstances, is unable to file the complaint or is prevented from doing so. If, however, she is unable to lodge the complaint due to physical or mental incapacity or death, her legal heirs may do so.
When the ICC receives a complaint, there can be 2 scenarios. The first way is to resolve the issue by way of conciliation if the complainant so wishes. The internal committee may, before initiating inquiry and at the request of the aggrieved woman, take steps to settle the matter between her and the respondent through conciliation. No monetary settlement can be the basis of the conciliation.
The Internal Complaints Committee shall have the right to terminate the inquiry proceedings or to give an ex parte decision on the complaint, if the complainant or respondent fails, without sufficient cause to present herself or himself for 3 consecutive hearings convened by presiding officer. Provided that such termination or ex parte order may not be passed without giving a notice in writing, 15 days in advance, to the party concerned. The parties shall not be allowed to bring in any legal practitioner to represent them in their case at any stage of the proceedings before the Internal Complaints Committee. The second scenario is, where no conciliation can be met. At the time of filing the complaint, the complainant shall submit to the Internal Complaints Committee 6 copies of the complaint along with supporting documents and the names and addresses of the witnesses. On receipt of the complaint, Internal Complaints Committee shall send 1 copy of the complaint to the respondent within a period of 7 working days. The respondent shall file his reply to the complaint along with his list of documents, and names and addresses of witnesses, within a period not exceeding 10 working days from the date of receipt of documents specified. The Internal Complaints Committee shall make inquiries into the complaint in accordance with the principles of natural justice. Internal Complaint Committee must start an inquiry into the complaint, which must be completed within 90 days. Where both the parties are employees, the parties shall, during the course of the inquiry, be given an opportunity of being heard, and a copy of the findings shall be made available to both the parties, enabling them to make representation against the findings before the committee. For the purposes of making an inquiry, the ICC shall have similar powers as a civil court. It can summon and enforce the attendance of any person, examine him on oath, order production of documents, etc. During the pendency of the inquiry, interim relief may be granted to the aggrieved woman. The ICC may recommend the employer to transfer the aggrieved woman or the respondent to any other workplace, grant leave to the aggrieved woman up to a period of 3 months, restrain the respondent from reporting on the work performance of the aggrieved woman or writing her confidential report, and assign the same to another officer. On completion of the inquiry, the committee must submit its recommendations to the employer, within 10 days from the completion of inquiry. The employer must act on those recommendations within 60 days in accordance with the conclusions of the inquiry. If the respondent is found not guilty, certainly the inquiry will end. If guilt is proven, the actions which could be taken could be deduction from the salary or wages of the respondent, an appropriate sum to be paid to the aggrieved woman, or to her legal heirs. Any action including a written apology, reprimand or censure, withholding of promotion, withholding of pay rise or increments, terminating the respondent from service or undergoing a counseling session or carrying out community service.
What can be done if a woman has filed a false complaint of sexual harassment against a colleague, a senior or a junior employee? If the ICC or LCC is of the view that a malicious or false complaint has been made against respondent, it may recommend any action against woman, including a written apology, reprimand or censure, withholding of promotion, withholding of pay rise or increments, terminating such person, complainant from service, or undergoing a counseling session or carrying out community service. However, an inquiry must be made in order to establish malicious intent. Please remember, mere inability to substantiate a complaint will not attract action under this provision.